Well, hello. Today is Wednesday, the 27th of February, and a new thing happened up on the Hill today, and that was we had no committee meetings in the afternoon, and it's going to do the same thing tomorrow, which gave us a full 5 hours of floor debate in the House and the Senate today. So a lot of stuff got covered. I also wanted to mention today was day 31, so only 14 more days, and this session of the legislature is over. So what happened today and what was going on? Well, one of the most contested bills up on the Hill today that actually underwent close to about 45 minutes of debate was HB 132. This bill came out a while ago. It's Kim Coleman's Higher Education Student Speech Rights. Now, as we've all seen and have become aware, free speech is definitely under attack these days. And one of the biggest ways that it's under attack is coming from this idea that whenever you say something, you may be hurting somebody's feelings. And if you hurt somebody's feelings, oh my gosh, you should be stopped. We shouldn't have to listen to you, and on and on and on. And so this is happening all over the country. And especially up at a college campus, one would think that if anywhere there would be the opportunity for the freedom of expression, the freedom to say what I want without, having repercussions sought against me, that's where you should be able to do it. Well, that's not the case. So before we get into it, let's make sure that we all know there is this thing called the Bill of Rights, and the First Amendment says this: Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of the people peaceably to assemble and to petition the government for a redress of grievances. So there it is, right in it, abridging the freedom of speech. No law. So how did we get in this conundrum? Well, there's been this idea that thought crimes and what you think or how you make a person feel in of itself should be a crime. And this is just lunacy to me. But if you do a quick Google search for free speech on college campus, I thought that was kind of a specific search. Little did I know, 120,000 results pop up. So in this bill, Representative Coleman came out, introduced a bill, which I thought she did a very good job with that. And then she was hit. And it was coming from all sides. It started out that a couple Democrats went at her, and then Republicans were going at her. I've got the link down below so you can watch that. It starts at about the 128 mark. There's also markers where if you just click on her bill, HB 132, and it'll fast forward you right to that position in the debate. So what happened? Well, she was really focusing on a 1999 Supreme Court case, which was Davis versus Monroe. And in that decision, the Supreme Court came out and said, you know what? Free speech on a college campus is okay as long as it's not discriminatory. So that's what Representative Coleman sought to do. Now, where I got a little bit out of focus, in my humble opinion, is how is that arbitrated? So in the event that somebody feels like that their free speech has been used incorrectly and that that's actually been a discriminatory act against a person, then that person can take judgment against the university. And during that process, the government cannot seek reparations from that individual. So the trouble that starts to get into, and that's actually line 88 through 90, is that it's this one-way attorney fees. And of course, we've got way too many attorneys up there in the state legislature. So they were all jumping on, oh my goodness, you can't have one-way anything because then that way the plaintiff will sue. And in the event that it's a frivolous lawsuit, the university cannot go after that individual. And this is what everybody was focusing on. We also had lines 91 through 94, and this actually waives immunity to the university. And again, quoting case law. Let's pause here for a moment. What we never want to do, or what my advice is always, is we want to base our actions on the Constitution and not be seeking case law. These are interpretations of a law. But guess what? Those interpretations are always subject to question and always subject to reinterpretation. So would it be better to focus on that or the First Amendment? And we did hear the First Amendment quite a bit, but during the debate, it got off into the weeds a little bit. I was also quite upset over this particular quote that was brought up. And the quote said, "A good idea does not make for good legislation." And that was actually brought up by our friend, Representative Waltrip over here, over at Desk 45. He's also a real estate consultant and has been up there just kind of new, a couple years now. But he said, you know what? This isn't addressing all the issues, or maybe the timing is wrong. So again, not to get off into the weeds, it ended up passing by the skin of its teeth. So we'll see how it does in the Senate. Like Representative Coleman mentioned in her presentation, this is the same bill she tried to run last year. It made it through the House and it failed in the Senate. So let's see what happens. We also had a few new bills that popped up. One was HB 443. This is a prohibition on age-based testing for physicians. That pretty much sums it up. Currently, a physician, once they reach a certain age, they could be tested to see if they're still cognitive and have the abilities to be a physician. That's going to be wiped if this bill goes through. There's also SB 210, kind of an interesting one. So let's look at the lines here. But this is all about body cameras. This is brought to us by Senator McKay, and line 66 through 73 says this: during a conversation with a victim of a sexual offense as described in Title 76, Chapter 5, Part 4, Sexual Offenses, or domestic violence as defined in Section blah, 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 if the officer is conducting an evidence-based lethality assessment, the victim or the officer believes that deactivating the body-worn camera recording will encourage complete and accurate information sharing by the victim, or is necessary to protect the safety or identity of the victim, and the officer's body-worn camera is reactivated as soon as reasonably possible after the evidence-based lethality assessment is complete. I don't know how I feel about this one yet. We'll have to get some more information, but initially, I'm very skeptical of this. I like that our employees, peace officers, have a camera on. It protects them as much as it protects us. So the idea of shutting that off while they are in the normal course of their business is something that just doesn't sit really well with me at this point. Another one, two part of me that are going to be heard tomorrow is HB 340. This is Rampage Violence Prevention Study. Again, brought to us by a former police officer, recently retired, Representative Perry. Again, bringing up my age-old question, when should these legislators recuse themselves or step away from something where there is a conflict of interest? Then there's all SCR 9, so the Senate Concurrent Resolution 9, which is a resolution addressing the Olympics and basically saying that the Senate loves the fact that we are looking at bringing the Olympics in. We also had, like I said, 37 bills were heard in 5 hours, 10 were opposed, and 5 were opposed with over 10 votes. So most of them, you had 32 bills that just flew through. Nothing failed today, by the way. So in addition to the one that was heavily challenged by Representative Coleman, HB 132, we also had HB 299. This was opportunity zone enhancements. And this is where particular zones within the state, we would love to have those set up as a charging zone, affordable housing, or a parking lot. And we only have a couple more years to get on that one. We also had HB 294, which was about mining operations amendment from one of our most quiet representatives up on the Hill, that being Representative Brooks. Here he is. And that one was just trying to say that gravel is not gravel, sand is not sand all over the place, especially in southern Utah. Lava rock is thought to be or is defined as bedrock. In St. George, we've all been there, I think. Lava is right on top of the sand. So difficult to say I've already hit bedrock. So that one was also contested. And then HB 240, driver's license revisions. Interesting one here. 22 people opposed it. And this would be for a sticker to be placed on your driver's license if you're handicapped. Again, equal protection under the law, ladies and gentlemen. And the argument is all, well, it's for safety. It's for this. It's for that. But again, should we really be asking or treating people differently? I don't think so. And even in the committees, it was brought up, well, the training of our officers is consistent that when they walk up, they should be able to assess, am I dealing with someone who has a type of disability that they may not be looking me in the eyes, they may be glancing back and forth, a sticker. Again, come on, is that really where we're at these days? So we'll see what happens tomorrow. 5 more beautiful hours up on the Hill tomorrow. Again, thank you as always for tuning in, and we'll see you guys tomorrow.